Yes.
Lordship, I'd like to mention item number 12.
12.
Lordship, if this matter, some person of the field is so if this matter be listed after 3 weeks, Lordship, I have taken the consent of the petitioner's affidavit.
It was fixed for today.
Lordship, I have some problem with the 546. I am some
You are appearing for the petitioner?
Union of India, Lordship.
Union of India. On a prayer made by
CCC.
the learned, on a prayer made on behalf of the learned CGSC appearing in the matter, which is not objected to by the learned counsel for the petitioner. List this matter after, or should we give a date?
After 2 weeks.
After 3 weeks. After 3 weeks. Yes. Any other?
Yes, my lord. My lord, I'm making mention item 15. I'm making mention on behalf of my senior Mr. P.B. Paul.
Okay.
My senior is out of station, lordship. So let it matter after 3 weeks, lordship.
You have informed the other side? Anybody there? Okay.
For the petitioner, my lord.
Okay. On a request
We
made
will
on,
file a counter affidavit.
who they are required to file the counter affidavit.
We will file our counter.
I'll file my counter affidavit.
You have filed it, they'll file a reply.
To enter to the counter.
Okay. On a request made on behalf of Mr. P.B. Paul, learned counsel for the respondents, comma, which is not objected to by the learned counsel for the petitioner. List this matter after
After 2 weeks, lordship.
3 weeks. Full stop. Petitioners may file their affidavit in reply in the meantime.
My lord, I think to mention item 14.
Yes.
For the respondent number 1,
Yes.
I paid 3 weeks time to file our reply to the counter additional affidavit filed by the petitioner.
Mr. So-and-so, learned counsel, appearing for the respondent number 1, raised for 3 weeks' time to file their counter affidavit to the additional affidavit filed by the, on behalf of the appellants. Prayer is allowed. List the matter after 3 weeks. Yes.
May I place your lordship?
Yes.
My lord, I beg to mention item number 4.
4.
4.
Okay.
Let this matter become up after 4 weeks. I've served the extra copy of the only.
A prayer is made on behalf of the petitioner.
My lord, I'm the respondent.
On behalf of the respondents for the matter to be listed after 4 weeks, since a copy of the
Petition, my lord.
review petition.
No, yes.
You are filing, you have filed the review.
No, yeah, he filed a petition or filed a review petition.
Review, and you have given him a copy of what?
I've served the extra copy.
Acha.
So on the last
Today only it was served.
I've served the extra copy.
Okay.
On the last of
What did he
petition,
say?
court have directed to file objection.
What did they say? Since he has been served a copy of the review petition today morning itself. Accordingly, list the matter after 4 weeks. Yes.
My lord, again, I beg to mention item number 11.
11.
Yes. I yet to receive instruction, my lord, I'm for respondent number 7.
What about the petitioner?
Lordship, yes. No objection. I've received the affidavit of the government. I may need some time to go through and file a reply if need be, lordship.
But he says he's yet to receive instructions. You are
Yes,
paying
He's
for
for the
Respondent number
7th.
7.
Okay.
I've
On
received-
a prayer made on behalf of the counsel for the respondent number 7, that he is yet to receive instructions. List this matter after
4 weeks, my lord.
4 weeks. The prayer is not objected to by the counsel appearing for the petitioner.
Lordship is an interim. Kindly let him continue, lordship.
Interim orders, if any, shall continue.
Kindly oblige me.
Yes.
Please, Lordship. Lordship, I beg to mention here, admission item 7. Lordship, here I am for respondent number 1, the claimant. Only in the last occasion, in Lordship, we have filed our vakalatnama if 3 weeks' time may be granted to file our.
When was that last occasion? When was the last date? 19th of August.
19th of August.
But we fixed it. 19th, I must have fixed it. Why did I fix it? Let the matter reach. Will not pass any adverse. Let us see why we fixed it. Let's just go through it once.
For motion,
Yes.
item number 1.
1 WP criminal fix.
May I please, Your Lordship?
Yes, sir.
Lordship, the petitioner's firm has 2 bank accounts, one in Kusa, Arunachal Pradesh, SBI, and one in Tinsukia, HDFC accounts. My Lord, these 2 bank accounts were freezed, blocked by the banks. On queries, it's learned that this has been blocked or freezed on the instruction of the NIA in connection with a case which is pending in Dimapur before the special court, NIA special court. Lordship, initially we thought that it was only during the investigation, the petition, but it is still freezed. And then we made a request to furnish us in return the reasons for freezing my account. And that reason was furnished to me. My Lord, may kindly come to page 63. This is the letter from the branch manager, SBI. It's dated 5/5/2025. May I just read the relevant portion? With reference to your letter dated such, we have to state that your account, MS Appo Enterprise, account number such, was stopped by NIA Kolkata on the basis of letter, NIA case number so-and-so, dated 9/12/2019. So it was blocked in 2019 because of this, in connection with this NIA case, which is before the special court at Dimapur. Then the second letter, there is the HDFC Bank, similar, same. Now, Lordship, I'm not an accused in the case.
You are not.
I'm not an accused. I was never an accused, nor a charge sheet has been filed. There are 2 accused. My Lord, the allegations made in the charge sheet, which I have also enclosed, Lordship, is this, that one of them, accused number 1, is an NSN IM member. And in collusion with accused number 2, they have been extorting money from people from Arunachal Pradesh and sending it to the accounts of accused number 1 and his wife through various bank accounts. One of them is also my account. Now, my Lord, an NIA is involved because Section 17 of the UAP Act is involved. That is terror, funding of terror. Now, Lordship, UAP, since it's a special act, Lordship, the act is, UAP. Lordship, may kindly see first the definition of property at section 2(1)H, my Lord.
Yes.
2(1)H, the definition of property under the Act.
2(1)H, okay.
2(a). Property means property and assets of every description, whether corporeal or incorporeal, movable or immovable, tangible or intangible, and legal documents, deeds, and instruments in any form, including but not limited to electronic or digital evidencing title to or interest in such property or assets by means of bank credits, traveler's check, bank check, money orders, shares, securities, bonds, draft, letters of credit, cash, and bank account, including funds. So bank account also is property.
It's property, yes.
So now, this act provides the manner in which seizure can be made. Lordship, may kindly come to page section 25.
25.
Yes.
Okay.
May I read it?
Yes.
If an officer investigating an offence committed under Chapter 4 or 6, Section 17 is under Chapter 4, my lord, has reasons to believe that any property in relation to which an investigation is being conducted represents process of terrorism, he shall, with the prior approval in writing of the Director General of Police of the state in which such property is situated, make an order seizing such property, and where it is not practicable to seize such property, make an order of attachment directing that such property shall not be transferred or otherwise dealt with except with the prior permission of the officer making such order, or of the designated authority before whom the property seized or attached is produced, and a copy of such order shall be served on the person concerned. Number 2, subsection 2, the investigating officer shall duly inform the designated authority within 48 hours of the seizure or attachment of such property. Subsection 3, my lord, the designated authority before whom the seized or attached property is produced shall either confirm or revoke the order of seizure or attachment so issued within a period of 60 days from the date of such production, provided that an opportunity of making a representation by the person whose property is seized or attached shall be given. For, in case of immovable property attached by the investigation...
We are not interested in that. It is not for immovable property.
It's not immovable property.
So we don't go
Oh,
into
yes.
that. We stay where
Yes.
we are.
Yeah, Lordship, then may I kindly come to 6 then, subsection 6.
Yes.
Any person aggrieved by an order made by the designated authority may prefer an appeal to the court within a period of 30 days from the date of receipt of the order, and the court may either confirm the order of attachment of the property or seizure so made or revoke such order and release the property. Now, my lord, before a seizure is made, before the seizure is made, first the investigating, the person who's seizing, the officer who's seizing must get a approval in written from the Director General of Police. Then he makes the seizure, he passes the order of seizure. The order of seizure is also given to me, to the person concerned, and then, my lord, that is sent to the designated authority within 48 hours. And then it has to be confirmed by the designated authority within 60 days, confirm or revoke. But before doing so, I must be given an opportunity.
Yes.
Now, if that is done by the designated authority, my only remedy is, my lord, to go to the special court within 30 days. In this case, my lord, nothing has been given. They just seize it, no documents provided, nothing. Even in the charge sheet, in the track, because I'm representing one of the accused there, nothing is there.
What about section 7?
7, yes, Lordship. This is regarding funding, prohibition of use of funds of an unlawful association. Here also, my lord, here, Lordship has rightly pointed out, here also, unlawful organizations' fund can be prohibited, but there's a process. The process has to be only that. My lord, similar case came up in the Madras High Court.
No.
In section 7, here, an organization's fund was prohibited to be used, but they did not follow the procedure. A writ file was filed, writ was allowed, saying this illegal. Now, Lordship, under PMLA, there's similar provision for freezing of accounts.
Yes.
In a case in Supreme Court,
Because what I feel is that in this case, your account has not been seized, it has been frozen.
It's frozen.
Then it would come under section 7, not under...
No, my lord, prohibition of use unlawful organization.
So therefore, let us read. Where an association has been declared unlawful by notification, which has become effective, and the central government is satisfied that any person has custody of money, security or credit, which are being used or are intended to be used for the purpose of unlawful association, the central government may by order in writing prohibit such person from paying, delivering, transfer or otherwise dealing in any manner whatsoever with such money which may come to his custody after making the order, save in accordance with the written orders of the central government, and a copy of such order shall be served.
Even if this is the case,
So now,
even if this is the case,
they have requested the bank not to allow you to
no,
do, but this is not the
whether
procedure.
the process has been followed. Here also the process has not been followed, my lord. Even if this provision is attractive,
It has come up for motion.
this could come for motion, my lord.
We will issue notice.
Yes,
NIA is a party
NIA is a party, my lord.
and
And the bank is a party.
you don't
And-
serve
No, my lord, the
advance copies
central
to
government
NIA.
doesn't accept notice on behalf of NIA. The central government council here and does not accept.
No, the NIA
NIA has
has
to be sent by post and they are not here, my lord.
but they do not have
No
a standing
council
council
here,
in
my
this
lord.
court.
No standing council here.
Okay. Heard, Mr. You are
Inti Longjam, my lord.
Inti Longjam,
Yes, ma'am.
appearing for the petitioners. This petition has been filed being aggrieved with the freezing of the bank accounts of the petitioner's firm on the instructions of the NIA, and you read the full form, National Investigating Agency, in connection with NIA case number, please take from page 2. Okay, I'm giving it as A to A, huh? Pending before the so-and-so, alleging that the said account has been frozen without following the due process of law. Our attention has been drawn to the letter dated 5/5/2025 issued by the State Bank of India Khonsa branch, District Khonsa, Arunachal Pradesh, and the letter dated 10/4/2025 issued by the HDFC Bank at Tinsukia, informing the petitioner that the accounts in the respective banks have been brought to a hold on the basis of notices received from NIA agency Kolkata, full stop. Issue notice, returnable in 4 weeks.
Yes, Lordship.
The petitioner shall take steps for service of notice by usual process as well as registered AD within a period of 3 working days from today. Do you need any prayer for interim?
No, my lord, no interim prayer.
Okay. List the matter after 4 weeks with service report.
Much obliged.
For admission, item number 2.
As per the last order, my lord,
Yes.
the contempt respondents are supposed to bring on record the steps taken by them in order to comply in pursuance of compliance of this honorable court's order.
Yes,
They have already submitted on previous occasions that it is under process.
yes.
Yes, Your Lordship. What happened is that, Your Lordship, I've already submitted that on 10th April 2025, Your Lordship, a vacancy was identified and it was sent for proposal. Now, after that, Your Lordship, when it was sent for proposal to the nodal department, that is PNAR department, Your Lordship, the PNR wrote back that there is some documents which need to be resubmitted again. So after, on this regard, I received a letter that the PNR, the nodal department, has sought for clarification. When I went through, I felt that like a PNR is a little bit unaware of the fact of the case, and in fact, they are asking again that regarding the DLC or the seniority position of the contingency. Because here is a little bit, there's a peculiarity in the case, Your Lordship. The petitioner was appointed on contingency. It was on compassionate, Your Lordship, but since there was no vacancy, the petitioner was appointed on contingency, and with the remark that as and when the vacancy arises, the petitioner will be appointed. However, the government overlooking that thing, Your Lordship, they overlooking that thing like he was not appointed. That's why they came before this court. This court says no, he should be regularized because it is a compassionate appointment. Therefore, Your Lordship, since the PNR was not able to understand the position, I make a clarification with the department to immediately write a letter to the PNR.
PNR is what? PNR's full form is what?
Personal and administrative reforms. They are not
Are
the
they party
department.
here?
No,
my lord.
unfortunately, they are not a party here.
Which is why, my lord, I pray that impeachment of PNR may be allowed, my lord.
That
How can I do it on the air?
is,
My lord, it can be done, my lord. In fact, in contempt proceedings, even third party who are not original parties in the,
No, they can be, There is no difficulty on that.
yes, my lord.
But can I do it on an oral prayer? Show me the paper.
so
I may
this,
be allowed to
Show me the paper.
file an appropriate IA, my lord.
Your Lordship, this is the.
But that has to be on record, that has to be brought to your knowledge.
Lordship, lordship.
I have already.
by some-
And this is the latest one, Your Lordship, the letter written to the PNR again by the department. Your Lordship.
Your department is doing what it can do.
Again, they have written to the
No,
PNR.
your department is doing what it can do.
Yes, Your
You are
Lordship. This is the identification, Your Lord. The first.
The Commissioner and Secretary, Chief Engineer.
That was the first letter when the vacancy was identified, Your Lordship.
Can you give him a copy of this?
I've already given, I've already intimated.
Take down. Ms. Lidika appearing, Lord Counsel appearing on,
For all the contempt.
Lord Counsel appearing for the respondents in the present petition has submitted that though the contemners have taken earnest steps for ensuring compliance of the orders passed by this honorable court, certain queries have been raised by the P&AR department for which the complete compliance is taking time. She has produced a letter dated 11/8/2025 along with their annexures,
Observation. Your Lord.
along with their enclosures, which also contain the observations made by the Deputy Secretary to the Government of Nagaland in the P&AR department. The learned counsel for the petitioner has submitted that on the face of the orders passed by this court, the queries raised by the P&AR department are nothing but an attempt to delay the compliance of the orders.
Your Lordship, that may not be the reason. because-
I'm saying he made a
Okay,
submission.
Oh, Your Lordship.
I'm saying he's making that submission. I'm not making the submission.
Okay, Your Lordship.
Okay. This has been objected to by the learned counsel appearing for the arrayed respondents. Full stop. The learned counsel for the petitioner prays for a short time to prefer or to file an application for impediment of parties whom implement of parties for proper appreciation of the matter. Prayer made is allowed. List the matter after
3 weeks, my lord.
3 weeks.
2 weeks,
2 weeks.
my lord.
2 weeks to enable the learned counsel for the petitioner to file the application. A copy of the letter dated 11/8/2025 is kept as a part of record. The respondents in the contempt petition may file their affidavit before the next date fixed. List on, when do you want it?
After 2 weeks, my lord, on a date to be fixed by the
On a
registry.
date to be fixed by the registry. You file your affidavit, bring on record
Oh,
all
Your
these
Lordship,
documents that you are doing your part.
Yes, Your Lordship.
Then we'll see who is not doing their work.
Oh, Your Lordship.
Keep your
Find
black.
out.
Item number 3.
But this is a case
Yes.
where I have invoked my Lord's jurisdiction under Article 227 of the Constitution, read with 528 of the BNSS, for quashing of the criminal proceedings which is kept pending against me. I am a retired director of the Land Records Office of the Government of Nagaland. Over a report of 2013 given by CAG, which has been rejected by the state of Nagaland, there is no FIR against me. Just because some opinion, a view, tentative view is taken, audit reports are tentative units, that is sent to the government, government accepts, not accepts, there is a procedure, set procedure. So, since the government has rejected that report itself, now it is the state of Nagaland which has rejected, no criminal case could have been otherwise also maintained against me. So, that report was not available earlier with us, now we have got a copy under RTI, the fourth report, secretary. So, my lord, nothing survives.
When did you get
Actually,
this?
if my lords can see the order of the 24th February 2025, that will give an idea to my lords. Honorable Court has noted the grounds in summary. So if my lords can see that. My lords have got it? Yeah. My lord, second para. It is the case of the petitioner that he was Director, Land Records and Survey, Government of Nagaland, from 3/6/2014 to 30/6/2023. The erstwhile Vigilance Commission in the year 2015, by an office note dated, office note minutes, there is no FIR, dated 20th/4/2015, had initiated a criminal proceeding against the petitioner without registration of any FIR, as laid down under section 154 or 157 CRPC. In as much as office note at annexure A1 to the present criminal petition is a mere office note, and no cognizable offence of any kind has been reflected therein. It is further case of the petitioner that the report of the CAG basing on which the investigation was initiated is a mere report and tentative in nature, which is not final, and it is for the government department concerned to take steps on the same as advised. The petitioner also submits that he has since retired on 30th June 2023, but till date, no disciplinary action proceeding has also been initiated against him, being on these facts. The petitioner therefore prays for quashing minutes. So my case is very simple. That first of all, to trigger the jurisdiction under section 156, 1 of the CRPC, there has to be a compliance of 154 or 157. 154 is based on any information received by the officer in charge of the police station. Then it is recorded in the register which we call FIR. And then 156(1) is structured, police officer will investigate. 157 is where police officer, SHO gets information directly and he himself becomes the informant of complaint. So my lords knows it much better than me. So my lord, where is that? Unless 154 is complied or fulfilled, 156 will not be triggered. There is only one way where without 154, 156 will still be triggered, which is the London Magistrate under 163 directing the police to initiate criminal investigation. So my first objection or ground, and that is what has been recorded by the Honorable Predecessor Court, Millets, is that there is no FIR against me. In fact, On that very first hearing, the Honorable Court was pleased to ask the estate, learned counsel for the estate, to produce the FIR. Till date, they have not produced the FIR. We have inspected the file. We have taken the entire certified file. We have not found any FIR anywhere. So obviously, we can't go beyond the records of the Lokpal or police station. So if they have an FIR, they can show it. I will assist my lords. I am submitting, there is no FIR. Number 1 minutes. Number 2 minutes, everything has been initiated by the Vigilance Police Station based on an audit report which is tentative. There is a procedure prescribed in law that audit report, when it is generated, it is sent to the concerned secretary. Secretary of the government may accept, may not accept. In this case, Millet, secretary has rejected. And that is a state, that is the government of Nagaland. So how the another department of the government, same government of Nagaland, same state, can say that this is an information when that is being rejected as incorrect? So Millet, that is also third, Millet, none of the withdrawals are during my period. They are prior to my becoming director. So that is for the previous directors. Of course, they are also made accused. For them, separate proceedings will be there. But for me, I have not found to be guilty of any misplacement or anything. So let's on merits also, on facts also, I'm not accountable for anything. And Millets, I'm suffering. My retirement proceeds are held up because of vigilance clearance is not being given.
Your
Retirement proceeds, Millets, because pendency of criminal case, because of the Janki Raman case of the Supreme Court, any of the three eventualities, if it takes place, then you are not given vigilance clearance, without which you will not get anything. That is
not anything.
suspension.
You will have your provisional.
Provisional, Millets.
You will have provisional.
Provisional pension.
Only your DCRG and
Other benefits will be held up.
DCRG and something else.
Yeah,
will be
yes,
held up.
this,
Even your leave,
gratuity,
gratuity and that is what DCRG, that comes retirement
state may
gratuity.
be calling it. So, Millet, but
Only DCRG is held up.
medical benefits are not given, other things are so, and plus stigma, all those things are there. Why should I suffer when there is nothing against me? That is my respectful. That's why court has protected me. In fact, on the very first hearing, my lords were pleased to protect me from any coercive action.
You've seen that.
So, state is not filing replies.
Yes. What do you want to do?
Lordship, I'm yet to receive instruction, Lordship. So if Lordship...
From whom?
From the land report, Lordship.
Huh? From whom? Who is the respondent you are expecting any instructions in this matter? Huh?
The respondent one is a land revenue, Lordship.
It's not only a state, Millets, state of Nagaland.
Yeah, I don't think you will have any instructions from respondent number 2.
I mean, that's
The Nagaland Lokaयुक्त is not going to
vast
give you
an
instructions.
organization.
And
Lordship, I'm appealing for respondent number 1, not for respondent number 2.
2.
I'm for respondent 1.
And you have taken your steps, the service report, what does it say?
Yes, Millets, service is complete.
On 2?
Everyone, Millets, all three. 3, of course, is part of 1 only, because he is an officer of the state, but 2 is a separate statutory body.
Yes, the state does not want to contest.
Lordship, in fact, there is a development, Lordship, on March, Lordship, the matter has been disposed of, Lordship, by the Lokaयुक्त, Lordship, and that has been submitted to the Secretary, Lordship. However,
He is challenging the proceedings before the Lokaयुक्त and it has been disposed of in March. And this petition was filed in?
February, Millets. My
February.
lord's order is of 24th February.
so there is a development,
Would
Lordship,
you,
but in fact,
would you like to verify?
Millets,
Find
we
out
have
if
not
it is
received-
already,
we
if
have
it is
not-
already disposed of.
Yes, Millets.
and the
That's what
matter
we
is
need to
before the
Millets, we have
government,
not received anything.
Lordship.
Now, Lokayukt's report is only advisory to the government.
No, whatever it is, what is your challenge?
I'm challenging the initiation of proceeding itself.
Of
Of the
Before the-
business, Lokayukt was created in 2017, years after the enactment of Lokaयुkt Act. So this proceeding was started in the Vigilance Police Station by the Vigilance Police Station, and subsequently Lokaयुkt took over because of the enabling provisions in the Act.
Yes.
So Millets, I am
So now
challenging,
if the Lokayukta has disposed of the matter,
that is what my brother is saying.
then everything goes.
No,
Whichever ways, if he has gone against you, you
I
have
don't know, Miller, because
you
I
have
have
to
not got
challenge
the
that
copy.
part. And
Obviously,
and if it has,
Now
let
it
us
will
say,
become in
use the word acquitted. If it
But
is
Millets,
acquitted
acquittal,
you,
Millets, that
you're
is
fine.
that is the whole thing problem is. Millets, Lokayukt's report is not binding on the government. Government may accept, may not accept.
ultimately whatever was there before the vigilance
Yes.
was transferred to the Lokayut.
Yes.
So whatever now
the
he
act
says,
itself.
whatever now he says,
Yes.
is what is the report the vigilance could have given.
I'm due respect, Millets.
Ah,
I'm just
please,
assisting Millets.
I'm-
What I'm saying, Millets, that since nothing came into being at the very initiation threshold, that is 2015, when the local police station started this proceeding, my respectful submission is nothing got transferred to Lokayukt also. Nothing can be transferred to this honorable court, my lord, which is not in existence. So Millets, that's why I'm challenging the very initiation, Millets.
Before the
I
vigilance.
have a legal
So
issue.
let us have it this way.
Millets.
You are under protection as of now.
Lordship.
No, I'm retired.
No, you are under protection. of
I'm
the
protection.
court.
Yes,
You are
I'm
protected by the
I'm
court.
grateful, Millets.
You take a maximum of 10 days. I'm allowing you 10 days if you want to come up with any affidavit without instructions. You want to bring an affidavit stating that the Lokayukt has disposed it of, whatever you want to say. You take 10 days time when you do it.
That is very fair.
In the meantime,
Millets.
you bring
I
this
will-
report
I
which
will-
is not on record.
I will,
on
by way
record.
of an affidavit, by way of.
So on the next date,
Miles.
at least this court will have enough and more
Yeah,
documents
yes,
to
Millets.
try and
Actually,
dispose
this
of
we
the
obtained
matter.
under RTI, so we will file an affidavit, an
You
additional
bring it on
affidavit.
by an affidavit that this is the
Yes, so
documents.
this may be, it was not available with us earlier. So Millets, my
I'm allowing
respectful submission, the criminal proceeding should itself be quashed. Why
So
should?
we'll do it once.
State-
Either you, when you bring this on record,
Yes, Millets,
we'll have a better,
Millets. Idea of the
And-
whole thing.
you take a last opportunity to contest this matter. If you don't contest this matter, we don't need to write something long.
Millets, if they are a state,
In fact, the government has not.
What is
taken
that called?
decision
Doctrine
as
of
now.
non-traverse. You don't
Yes.
traverse his arguments, we.
yes, Millets, that, and ultimately it is a state
We'll go
who
by
is
what we deem
the
is
contesting party, Millets, because it is state's case.
And if you don't contest, then it is it is up to him to convince us.
Yes.
In accordance with law, we'll pass whatever we need to.
Lordship, 2 weeks time may be given, Lordship. In that way of the matter, Lordship, since we will be filing our.
See, from February to July, you don't have any instructions.
Lordship,
Since
in
February,
fact,
Millets.
Because on February, see, this is with the state.
Almost
An advance
7
copy
months.
must have been given to you.
Lordship, I have received, through WhatsApp, I have received the instruction, but officially it has not reached me, Lordship. So,
Need not. On your WhatsApp instructions, you build up your affidavit, you send to them, they are signing the truth or otherwise of the affidavit.
Lordship, 2 weeks time, Lordship.
Millets,
We are much
11th,
safer.
Okay, yes, sir.
11th September, I will be here for another case. In Gauhati, of course. So
In
Millets,
any difficulty on 11th?
Then on 17th, Lordship, 17th, on 17th.
And if you are appearing virtually,
Millets, virtually sometimes links are not.
or you'll
working.
come down from
And what
Gauhati.
is, I prefer, with due respect, Millets,
He is praying for 17th.
17th, I will.
Convenient to you.
No, 17th, of course, dates, Millets, my associate will, if my lords permit,
Okay.
subject to my lord's convenience, because it is
We
always.
will say list it after 2 weeks.
After 2 weeks, then subject to mutual convenience means, they will send.
Move a you move an application in the registry or whatever
We will
process
move
is
immediately,
followed.
within 2 days. And if they give us anything in advance, we will file reply to that also. But I'm strictly on law, there is no dispute on the facts, I'm not contesting anything on the facts, facts are on the record.
See,
Purely
without the affidavit of the state
mileage.
taking up the matter for disposal, without affording
But
them
Millets,
one last opportunity.
yes,
is what
Millets,
we
I
call
go
it.
down.
Give him one last
My
opportunity.
lords, I
Give
go
them,
down,
we'll-
I go down.
we'll go
My
ahead
lords are
there.
very fair. But if the state is not complying, because they are not bothered, because they don't have a case to defend, what will they defend?
If that was the case, they would not have started it at all.
Yes,
They are bothered.
They are, had there been something against me, they would have hanged me.
We'll see.
They have not initiated even DP against me. Department of Proceedings has also not been initiated. So they are just, leaving it to us, me to convince the my lords that.
Yes, take down. Heard Mr. S. Srivastava, Learned Counsel.
SK minutes.
S.K. Srivastava. Okay. Learned Counsel assisted by Mr. Lotha, N.Z. Lotha. Learned Counsel for the petitioner. And
For respondent number 1, Vijimon.
Mr. V. Zimomi, Learned Public Prosecutor. For the respondent number 1, not for 2, not for 3.
Not for 2.
3
I'll appear for respondent.
for respondent number 1.
Their officer.
Full stop. It is observed that the state respondents have prayed for time to obtain instructions and file their affidavit on the last several occasions, and in the order dated 25/7/2025, a further 3 weeks' time was granted to file the affidavit in opposition. Full stop. Today, again, a prayer is made that the instructions have been received that the instructions are yet to be received officially. Put it like that. And therefore, some more time may be granted to file the affidavit in opposition. Full stop. The Learned Counsel for the petitioner has submitted that they have obtained a copy of the report, of the audit report.
No, please.
Okay, what-
Copy of the letter of the secretary,
Letter of the
Secretary State of Nagaland, Government of Nagaland,
Secretary State of Nagaland,
by which this report has been rejected by the Government of Nagaland,
by which the report
of the CAG,
of the CAG was rejected by the government of Nagaland,
as incorrect.
and he prays for some time to bring on record the said document by way of an additional affidavit. Full stop. Reluctantly, this court grants a final opportunity to the state respondents to file their affidavit in opposition within a period of 2 weeks hence, with advance copy to the Learned Counsel for the petitioner, who may file their reply, if any, within a week thereafter. The petitioner shall also be at liberty to bring on record, or to file an additional affidavit to bring on record the letter which has been produced in the court today.
Well, let's say 18 June 2014, please.
18?
18
Letter
June
dated
2014.
18 June 2014.
This is Government of Nagaland official communication, please.
Then you say at the
Well,
end,
it's protection to continue.
yes, we do that. List the matter again on, again after,
Well, 3 weeks.
it has to be 3 weeks because I am giving you 1 week time to respond. List the matter again after 3 weeks. It is made clear that non-filing of affidavit in opposition may lead to adverse inferences. Stop. Interim order passed earlier shall continue in the meantime.
Well, grateful.
Kindly give this back. Yes.
Item number 5.
Yes.
My Lord, there is a delay of more than 1,400 days.
Notice is not issued. Notice is issued.
I do not know whether the respondent number 1 has entered appearance today.
Yes. Anybody appearing for respondent number 1? Nobody.
If the Learned Government Council has no objection, my Lord, then for the case to be decided on merit,
what is
my
your-
Lord, may kindly dispose of the.
No, I am also very, inquisitive to know how do you explain 1,000 days?
Yes, Your Lordship, it is quite difficult to explain this so many days of delay, my Lord. And
When was
definitely
the-
there will be loopholes here and there, my Lord, but an effort was made to ensure that the respondent, the concerned department, not responding department as well as the concerned department, that is the Department of School Education, Normally, in other cases also, they have made the payment to those employees whose GPF were fraudulently withdrawn, because in the year 2000, my lord, by an office memorandum, the state of Nagaland brought out an office memorandum that allowed an employee
No,
to...
what is this appeal about? Where is that order of the
Your
Supreme?
lordship, yes, the order of
What
the
are you,
lower
what are
court.
you appealing from?
Your lordship, it is at page 30, annexure 1 and 2.
We'll come to page 48 directly. Let us have the cause of action in relation to decided whether fraudulent final GPM proposed from government school so-and-so, the signature of so-and-so was the then DDO. The final report of the so-and-so has stated in civil suit the person to be
My lord, is at page 42.
or a compensation. No, I want to find that. You had prayed for your, what did you pray for? What was the prayer in the suit?
In the main appeal, my lord,
Yes, in the suit, what was the prayer? No.
in the suit.
In the suit, what was the prayer?
No, your lordship, it was
was
not a
the
suit
relief?
filed by the department, it was a suit filed by the respondent number 1,
Yes,
my lord.
and now the department is in appeal. Who is in appeal? Yes, Accountant General.
My lord,
What I'm trying to understand is what did the plaintiff ask for?
the plaintiff has asked for that
His
money.
share of the,
No, her money
Yes.
that was fraudulently withdrawn.
by someone else.
Yes, by someone else.
Yes.
Now, my lord, in so many similar cases that has been decided by this own court, the right to the employee to produce the original GPF statement to the office of the accountant general, and on verification, that only verification was whether the limited copies are given out, one to the department and one to the employee concerned. So if an original was brought without following so many procedures forward from the department to finance XYZ till reaching the office of the accountant general, it was approved so that the gap between the employee and the office of the AG was to be reduced. And it is by the office memorandum of the state itself. Oh, my lord, later on it was found out that it was abused by several unscrupulous individuals. And in this case also an original copy was brought, so it was approved. Later on, my lord, it turned out that some other person had actually withdrawn the amount from the account of the respondent number 1, who was a plaintiff. So, my lord, we requested the office of the Department of School Education to recover that amount, because in any case it has to be recovered. As far as the AG is concerned, we're only an approving authority. We have no financial authority. We're not a sanctioning authority. Now, your lordship,
Money
in
went
this
from
case,
whom? Money went from whose account to whose account?
your lordship,
You approved the transfer of the money and the money was transferred
no,
from.
money is not our part, your lordship.
Where?
We approved the papers that came to us because the original GPF statement was submitted to our office. And then it was the finance and the treasury, they will be the ones who are involved in transferring the amount to another person's account. As far as money transaction is concerned, that is not our responsibility, my lord.
Who is the defendant number 1? And why did the trial court hold you liable
Your
for
lordship,
payment?
that's the reason why we're challenging,
Why did the
because
trial
we're
court
not a
raise that
custodian of the
Because I'm
finance
trying
of the
to see
state.
if you have got a case, maybe we'll think of the limitation part. Yes, why were you held responsible?
Your lordship, then
If
shall I
the
take
money
your
goes from
lordship
the
to the...
treasury,
Yes,
if the money goes from the treasury
yes.
and other people, why were you held responsible?
May I take your lordship to the grounds that I have taken in the main suit? I have mentioned in the delay application also at page 15, my lord.
Okay, page 15. Yes.
May I read, my
Let us
lord,
just
the
see for 2
few
minutes.
grounds that I have taken? page 15 of my delay application. May I read, my lord? For that, a learned district judge, Dimapur, failed to appreciate it. It is not the duty of the office of the appellant to go to the departments, to all the departments, to check if every employee has received his or her annual GPF statement. It is clear from the statement in her cross-examination by respondent number 1, that is Asonon Dang, the plaintiff, your lordship, that she has received her GPF regularly, GPF statement, it should be statement, your lordship, regularly till 2001. But from 2002 till date, her retirement, she has not received, which clearly shows that she has not been vigilant on her part to keep her GPF statement checked for as long as 12 years. Then B, your lordship, for that, a learned district judge, Dimapur, failed to appreciate that the office of the appellant is only an approving authority. Office of the appellant is neither a sanctioning authority nor is authorized to sanction money or finance the claims of the GPF pension subscribers. For that, a learned single judge, Dimapur, erred in law by coming to a conclusion that the specimen signature of the applicant praying for final payment of GPF on 13/9/2002 is not the signature of the respondent number 2. The learned court below further failed to appreciate that the office of the appellant is not the investigating agency so as to ascertain the veracity of the documents. And D, your lordship, for that, a learned single judge, Dimapur, erred in law in coming to a conclusion that the office of the appellant accepted the forged documents without proper verification for final drawal and not the school education department, and hence the office of the appellant is responsible. That's how the learned court held. The learned court below failed to appreciate that there was no foul play detected by the office of the appellant, as the same was accompanied by the original copy of the GPF statement and a forwarding letter by the department. There was a forwarding letter also, your lordship, by the department. That a learned district judge, Dimapur, erred in law in coming to a wrong finding that the drawal was made from the office of the appellant and not from the school education department, and there was no lapse on the part of the respondent number 2, 3, and 4. That the lower court failed to appreciate that the office of the appellant acted as per the direction of the state respondents, that is OM 2000, your lordship, and furthermore, the office of the appellant is limited to examining whether necessary documents are produced along with the copy of the yearly GPF statement. That's the only role we have, my lord. The office of the appellant never approved any claim for GPF which is not accompanied by the original copy of the annual GPF statement. The learned court below failed to appreciate that the final drawal letter dated 27/9/2002 was signed by the headmaster, Purana Bazar, Dimapur, which was accompanied by the original copy of the GPF statement. That a learned judge, Dimapur, erred in law in further observing that the GPF withdrawal was not routed through the Department of School Education, Directorate of School Education, thereby making the office of the appellant liable by directing to pay the sum of rupees 3,90,340 within a period of 2 months, and in default, the office of the appellant shall be liable to pay the decretal amount along with the interest rate of 9% per annum from the date of the institution of the suit, that is 9/5/2014. For that, impugned judgment and order dated 25/2019 and decree dated 22/5/2019 is not maintainable. As such, it is respectfully submitted that the impugned judgment and order dated 25/2019 and decree dated 22/5/2019 are liable to be set aside and quashed by the Zone Court.
No, sir, but we are not satisfied with the manner in which the delay has been explained.
Yes, your lordship.
Too many gaps.
My lord, because your lordship will also kindly appreciate this one point. Earlier, now we have 2 standing counsels, including my colleague brother, Mr. N. Muji and I.
Yeah.
Earlier, the AG cases were handled by the learned CGSCs of this court. And my lord, there were some areas where we have to point fingers also, your lordship.
No, we are taking all that into consideration. Even if you come to paragraph 14,
My lord.
that the legal opinion was expressed on April 2023. Is it not? In April 2023, an opinion was expressed that an appeal should be filed or not filed, whatever. Then you will see from April, in May, there was a request to comply on priority, and the reply came in August. June, July, August gone.
My lord.
Then if you come down,
Your lordship.
page 12,
My lord.
second paragraph,
The finance department.
Finance says that if you are not satisfied, go and appeal.
My lord.
Is it not?
Yes, your lordship.
Then it was submitted to the council on 24th October. We take into account the winter vacations, holidays, whatever, and we say that okay, it was fine. Thereafter on 5 to 2025, we don't have enough. But the in between part, department has been.
Your lordship, I also take responsibility because the file
No,
was.
that responsibility I have already, see, I am overlooking the responsibility at paragraph 14. I think that was the responsibility you can take. Up to para 14. Page 10, para 14, where you say that you gave your legal opinion.
My lord.
I'm with you. Fine. What about thereafter? This is a case where the retrial benefits.
My lord, in any case, and we are also not against.
On the one
that,
hand,
but-
we will see the plaintiff who is waiting for
Yes,
retrial
your
benefits, and on the other hand, we will see that the laxity of the departments, the AG or whosoever, the laxity, when money is flowing out of the department itself, they do not care for it. They
Your
skip
lordship.
over the matter or keep writing letters.
My lord. And now, my lord, one of the problem with
No execution filed.
No.
She did not file any execution.
Apparently not, your lordship. Now, one of the problem with the office of the principal accountant general is that we are not a custodian of the state finance. So,
No, it need not be when
Yes,
the
your
when you are saddled with the burden of payment, which you say is wrong. First day, first move.
so we requested
cannot
the
say you
department,
can-
but the department
Why should
conveniently
department-
wants to bank upon the
should-
judgment of the learned court below.
Why should the department file an appeal for the AG?
No, my
Department
lord,
is not
I'm
setting
not
with
saying
the
that, my lord. What I'm saying is, we were trying to request them to do it, but they
you
were
like
happy
to-
with the judgment of the learned court below. And now if we are to pay, my lord, well, we have to pay from our deduction from our own salaries, my lord.
Would you like to try on a better day?
If my
I'm
lord
not
may
convinced.
kindly,
I'm not convinced on this.
my lord, if the
What
case
they
may
say,
be allowed
tomorrow
to be
is another
contested
day.
in merit.
Huh?
Now, if my lord will not allow, then I doubt any other court will also allow, my lord. It is my respectful submission, my lord. Unless my learned friend would like to object, I beg your lordship to kindly allow us to contest the case on merit.
It has to satisfy my conscience. I try my best to do what would be good in law. What I find here is that a lady was defrauded of her GPF amount by whosoever with the involvement of certain departments or non-involvement because the departments did not take proper care. She goes to a court of law, she gets an order in her favor,
My lord,
settling a particular department with the responsibility of making the payment. That is where her grievance ends.
your lordship.
Now the department which says that I am not responsible sleeps over the matter for at least 7 to 8 months after they get an opinion from the council to prefer an appeal. The department decides to sleep over. Now allowing the department to agitate the matter now after this delay, will it not be totally detrimental to the
My lord, in any case.
orders passed? I'm not on what the plaintiff or the respondent here should get, but that order passed by the trial court, allowing something to be assailed after this long period without there being a proper explanation, I'm not very satisfied on that. Practically, I'm not satisfied on this thing. It is not about the quantum or it is not about the plaintiff who might have suffered some loss. But unless we pull up in 1 or 2 cases, departments will never, because what was that case? Department of Telegraph, what was it? Postmaster General something. Departmental intercommunication misunderstandings can never be a ground to condone delays for appeals. So what to do?
My lord, one of the fact remains, two if my lord may kindly allow me. Number one,
Yes.
the headmaster of the particular school where she was serving was found to be the person who has forwarded. So,
Did you file a criminal case against him?
Your
Recover it
Lordship.
from him. He goes scot-free.
yes, Your
He is
Lordship.
enjoying his GPF.
My Lord.
He
That's
did not have
number
to go
one.
to the court.
Number two, at the cost of repetition, if my Lord may allow me, we have to deduct from our salaries to meet the, if at all this appeal is not to be contested on merit and at this stage it fails, my Lord, then my officers will have to deduct from their salaries to pay for this.
See, all the money comes from the finance.
Yes, Your Lordship.
I have had that experience at least when I was representing the state. Finance me. I'm astounded. No execution, no representation now also
So respectfully, my Lord,
after paper publication.
if my Lord may kindly allow this matter to be contested on merit,
I
if not,
think if that is your prayer, then we will need some more time to think. We will list it after 1 week. Allowing the court to think some more, consider some more. Or
so my Lord, unless my learned friend has
it
objections,
is-
I beg
it
your
is-
Lordship to kindly
his
condone the delay.
objections will come in only when there is something in my mind to say that
Then can it be listed tomorrow, my
Reserves.
Lord, before my Lord goes? If it can be listed tomorrow. Because I beg your Lordship to kindly,
but I'm not convinced to condone it. So let us do it today itself. Yes, take down. You finish it today, you will have your own news. Okay. This interlocutory application has been filed by the Principal Accountant General, Office of the Principal Accountant General A&E, Nagaland, Kohima, hereinafter referred to as the applicant, comma, praying for condonation of delay of 1447 days in preferring the connected appeal against the judgment and order dated 25/2019 and decree dated 22/5/2019 passed by the Principal District and Session Judge Dimapur in civil suit number 15 of 2014, comma, whereby the appellant was required to pay a sum of rupees 3,90,340 with the interest rate of 9% per annum within a period of 2 months. Full stop. Your full name, sir?
my Lord, my name is Joshua Shike. But if my Lord
Joshua
may
Shike,
kindly
okay.
allow me my sincere apologies for my interruption.
Yes.
If the delay petition, condonation of delay petition is not inclined to be considered by this own court, then I may be allowed to withdraw so that I may give more thought and then try to give more illustrious.
What we do is this. Since we have written the order, in half, we will not strike it out. We are not in the habit of doing that. What I will say is that after some hearing, you want to file an additional affidavit explaining the delay more elaborately.
My Lord,
We'll allow you that time. Yes.
Your Lordship.
We have Mr. Joshua Seki appearing for the appellant has submitted that the delay in the filing of the appeal has been appropriately explained in the application and deserves to be condoned. He has also referred to some extent to the merit of the appeal to submit that in appropriate cases an inordinate delay may also be condoned if the appeal deserves consideration on merit. After pressing the matter for some time, Mr. Sheki prays for an opportunity to file an additional affidavit to explain the delay more elaborately. Full stop. The prayer is allowed. The applicants may file an additional affidavit to bring on record the explanation more elaborately. Full stop. List the matter after
3 weeks, my lord.
3 weeks.
Much obliged, your lordship.
Obliged, madam.
Item number 6.
Bill.
May please, your lord. May please, your lordship.
Yes.
Now, your lordship, the question in this case is more or less it is besides the case, your lordship. The question of
We have thought it over.
no, your
We cannot go beyond the records.
Whatever be-
Certified copies will not overrule records. Yes.
No, whatever be the thing, your lordship, now doubt has cast on the mind of this honorable court regarding the credibility of the documents, your lordship. Now, one thing that my lordship has detected on that day is there was a pagination, your lordship.
There was?
Pagination, your lordship. Pagination was not on the CTC copy, whereas there is a pagination here. When I go through the documents, I saw that like the court's copy, the court's order was also paginated. And when I saw the records, it was not on sequence. It would jumble up the pagination. So one thought came to my mind that how come, when the CTC was obtained, there was no pagination, and how come there was a pagination? So I asked the concerned person who has actually sent, and it was informed that PI directed the Peshkar to take out the tabulation. And as per the tabulation, it seems that the High Court are very strict when it comes to documentation, and they want it to be on as per the pagination. That's why the Peshkar, under a bona fide belief only, he paginated that one. So I say, okay, if that is the case, then let the court, because besides the case, my lordship, because since my lordship has already observed that there is a doubt
There are
on
two
the
things,
question.
there are two things which is playing in the mind of this court.
Yes, your lordship.
The manner in which the investigation is not being completed, you know the name of the person, those who have not been arrested till
Yes,
now,
sir.
they are still on the loose.
Yes, your lordship.
The investigation does not appear that they are taking enough interest. On the other hand, we find that the petitioner had surrendered. He was not required to be traced out or anything. He surrendered.
Yes, your lordship.
He
what
is
has-
there, he is cooperating with the investigation.
Yes, your lordship.
Then comes the question of whether he was told about his grounds of arrest and his rights.
Yes, your
I think day before yesterday, Supreme Court has again clarified it. Have you gone through the judgment?
Not yet.
Day before yesterday, there is a judgment
Okay.
by the Supreme Court.
I'm not aware about that.
that part about that particular format and all has
Yes.
been
Yes, sir.
discussed.
Yes, Your Lordship.
And the Supreme Court has also said that if giving you that limited information regarding your arrest may also be enough. Since it has come day before yesterday, I also have to go through it. But these two things are playing in this course, and we are not going to comment on whether the which of the records are correct.
No, that is the thing, Your Lordship. But since the court was already casting a doubt, and like it is a
No,
question of credibility, Your
it is
Lordship,
only,
that's why.
it is
Your
only
Lordship.
during the proceedings that we
Yes,
had a
sir.
doubt. We take your statement that this was paginated after the court for the records.
Yes, Your Lordship. And one thing, on the forwarding letter, it is written on the forwarding letter that they were given, the grounds of arrest was given taken as per section 48 and 47 of BNS, Your Lordship. You can kindly see in all the records, in all the
the records
forwarding
is given,
letter. So now,
But
Your
his
Lordship.
ground in the trial court, in the court where he first moved the bail application, there he took that ground that I have not been told about no grounds of arrest. That was not answered by the
Judge, by the presiding judge.
So
Because
that,
para 7, because
So rather than go into the aspect of whether you had you were intimated your grounds of arrest or not, we will try to find out whether you are a person who can be released on bail or not at this particular stage of the investigation. We will not go into that aspect of the matter as to whether
yes,
the grounds of arrest as informed to you are sufficient enough to uphold the arrest. Because that is only if we set aside the entire arrest, then we go into that aspect of the matter. But if we hold that if you otherwise whether you are entitled to bail or not, if we consider that aspect of the matter, I think that will also suffice.
madam, lordship.
So you will have the order by evening.
Madam.
Try to have it dictated in the
Madam.
recess and we'll try to have it. इसको dispose दिखाइए. We'll have the.
so that is.
I'm keeping this.
No,
I'm keeping the copy here for the time being. Whatever is yours, you can take it later.
Yeah, all the records are there.
Madam.
Yes, sir. Can you just explain me one more thing? I was
Yes,
having a discussion.
yes, madam.
There is a charge sheet which is filed if something is found against an accused. The police file a charge sheet if they think they can support the charges against the accused. They file a charge sheet that we have enough evidence. What is the final report? To my understanding, that we cannot support the charges. We do not find anything against him. Is the final report. What is the final form? In some cases, I have found the police are using the word final form. The APP is using that word. The final form has not been submitted. What is this final form thing? Any idea?
My lord, there are two things.
Yes.
One is supposing after thorough investigation, if there is no prima facie against me, there is some final report. they say.
Final report, I understand. Final report and charge sheet.
Then final form means charge sheet. Yes.
Then final form means charge sheet.
Charge sheet.
That is what we understand.
Because
Then this case is a mess. Very interesting.
yes, ma'am.
Anyway, thank you.
Yes, ma'am.
Thank you.
Item number 7.
7, was it mentioned? No. Oh, I did not allow the mention. Okay. I did not allow the mention. Yes, why did we fix it? There was some reason. No reason. Okay, why did you want time?
Lordship, I am for respondent number 1, the claimant. Lordship, if I may be allowed 2 weeks' time to file my objection for respondent number 1. Only on the last occasion we filed our Vakalatnama. It's my second appearance.
A prayer is made on behalf of the Learned Council, a praying for the respondent number 1 for accommodation for
2 weeks' time.
2 weeks to enable him to file the objections to the interlocutory application praying for condonation of delay of 57 days in preferring the connected appeal against the award by the Motor Accidents Claim Tribunal. Which district? From where? Mokokchung, Nagaland. Prayer is allowed. List the matter after 2 weeks.
For orders, item number 8.
Number 8.
Lordship.
Contempt.
Yes, Lordship. I am
Fixed.
preparing for response. Lordship, in the last occasion, I could not attend the court because I was not feeling well, so I have informed one of my junior to mention. Lordship, the order has been complied with.
Yes, what do you say for the petitioner?
Lordship,
My lord.
in fact, nowadays the procedure has changed a little bit. Now, every employee has to be registered under the PIMS. That is Personal Information Management System.
Yes, PS, yes.
PIMS. Now, once the person retires,
The
any-
PS goes.
Yes, it goes. So to make the payment, it was already approved from before. But the PIMS issue came. So the matter was sent to the Treasury for its authentication. Then it was sent to the Finance, Lordship. And Finance is ultimately cleared because this is a court case. So Lordship, may kindly come to the letter of from the Finance Department, Lordship, 5th August. So it's not only the petitioner. There are many of them, Lordship. So the total amount that was sanctioned was 2 crore 22 lakhs.
No, this you have written to the Chief Medical Officer
Yeah, PEG. Lordship,
To
can
make
come
the-
Annexure 3.
to make the payment.
Yes.
To make the payment. Has he made the payment?
No, we have written a letter on 13 August
Yes.
to the CMO, the first letter, Lordship,
Yes.
to release. Lordship, may kindly see the annexure.
No, there will be no second letter to him. The CMO, if he is not complying with your release orders and the orders of the court after you release the money,
Yes.
there will be no option or time for you to write a second letter. He will come and receive whatever he has to receive here.
No, it'll be from the CMO, from the place he has retired.
That is what I'm saying. Where is that place? You retired from fake.
PEG, yes.
So that is what I'm saying. Once the finance has cleared it, why is the CMO holding it back for the last 10 days?
No, Lordship, as soon as we have received the letter,
Yes.
we have written to the CMO to release that.
Anybody appearing for the CMO?
Lordship, I'll be praying for the medical department, Lordship.
Get back to us tomorrow.
Lordship.
Give him a copy of this letter on his WhatsApp.
We have already sent, Lordship.
He knows
Already.
then whether he has made the payment.
Lordship, now they have to go and get the money from the treasury.
So whether he has returned to the treasury or not to get the money.
Lordship,
That is what I want to know. What are the
Yes,
steps
that-
taken by your client? He has not said whether he has received the money or not.
No, my lord, he has not received.
This is for respondent number 1 and 2,
Lordship.
compliance.
Yes, Lordship.
3. Respondent number 3, we need the compliance. So how to do it? When can he give me a compliance report?
Lordship, I will be given some time, Lordship.
Because once he gives it to the treasury, he's done his part.
Yes, yes. No, Lordship, the second letter from the finance department is to the treasury.
Then why is the treasury not releasing it?
No, Lordship, the money has been sanctioned, Lordship.
Yes.
Lordship, may kindly come to Annexure 3.
I understand. For
Yes.
1 and 2, job is done.
Lordship.
But he has not got the money till now.
Yes. Now the issue is the treasury.
Yes.
It has to be released from the treasury.
Yes.
The treasury is not a party in this case, Lordship. That is the issue.
Not necessarily. We'll make him a party today and we'll bring him here tomorrow.
Now the whole issue came up because the government approved the release of the back wages to the petitioner. Now when the money was sent, the approval was sent, the sanction letter. The treasury pack, they rejected on the ground that without the PIMS, we cannot transfer the money. So the CMO wrote back to us saying that there's a refusal on part of the treasury.
Till now, whatever delay was there,
Yes.
you are trying to comply with the orders. We are
Yes,
not.
Lordship. Now, immediately on receipt of the letter from the CMO, we wrote to the Treasury Department, Treasury account, that this is the issue now. In spite of the approval of the sanction letter from the government, we are unable to pay the petition. So, the matter was referred to the Treasury.
Please take down. You are Mr. Sophie.
Yes, my lord.
Heard Mr. A. Sophie, learned counsel for the petitioner. Also heard Mr. N. Muzoi.
N. Muzoi.
N. Muzoi, learned counsel appearing for the respondents.
Respondents, Lordship.
Mr. Muzoi, learned counsel for the respondents, has placed a letter dated 13th of August 2025,
Lordship.
issued by the Principal Director of the Directorate of Health and Family Welfare, Nagaland, Kohima, to the Chief Medical Officer, FAKE, informing him that the authorization that the Finance Department Budget and Monitoring Cell had authorized the release of back wages for the period from 1/4/2022 to 31/3/2023,
Lordship.
amounting to rupees 1,46,088 rupees only in respect of the petitioner. Copy of the said letter dated 13th August is kept on record. Mr. Mozui, appearing for the respondents, prays for a week's time to bring the updated status report from the respondent number 3 regarding payment made to the petitioner regarding payment made to the petitioner. Stop. Prayer is allowed. List. We'll keep it when? 27th, 26th? We'll keep it soon. No, we'll keep it on. We'll keep it on 2nd of September. Take a few days more.
Yes, Lordship, I'll
List the matter on the 2nd of September 2025 to enable Mr. Mozui to produce the compliance report by the respondent number 3.
Lordship. Objection, Lordship.
Item number 9.
Please, Lordship. As per the office note dated 25/17/25, the service report upon respondent number 2 is still awaited, Lordship. More so, the
Who
respondent.
appears? Respondent number 1, who appears?
Lordship, I'm for respondent number 1.
Claimant.
Your name is?
No, sir. On behalf of B.N. Sharma, counsel for respondent number 1.
1.
Lordship.
Okay. Yes.
Lordship, so if 2 more weeks time may be granted, Your Lordship. 2 more weeks time may be granted, Your Lordship.
To them. To whom? You are
respondent
appealing
number
for?
2. For the appellant, Your Lordship.
You are appealing for the
Yes,
appellant.
Lordship.
And respondent number 1 does not have any objection to the
Lordship, I'll be
condonation.
I'll be filing my objection.
You will be filing.
Yes, Lordship.
Then we will reject your objection on the ground of delay. You took too much of time to file the objection. He is delayed in filing the appeal, you are delayed in filing the objection. What to do? Mr. So-and-so appearing for the counsel for the respondent number 1, prays for 2 weeks' time to file his objections to the interlocutory application.
11th of 2025. 11th of 2025.
To the interlocutory application, we are dictating the order in that application only. To the interlocutory application, praying for condonation of 25 days delay in filing the appeal. The service report on respondent number 2 is still awaited. List the matter after 2 weeks for service report, and also to allow the respondent number 1 to file their affidavit in their objections to the petition for condonation of delay. Yes, you are the insurance company.
Lordship.
You took leave to defend
Lordship,
in the.
regarding that, I'm not aware, Lordship. Lordship.
Then how will you maintain your? You see, I've given a judgment.
Yes, Nicoleta Rotagi.
Yes.
Yes.
Nicoleta Rotagi. Why don't you go through it? If you don't have a case, why delay it?
Lordship.
You also go through it. You know about Nicoleta Rotagi? No.
I'm appear under instruction.
You contest it on merits by judgments. Why do you want instructions? See, clients are supposed to give you material instructions, but you are supposed to have your own instruction. Material instructions, it is the client. No problem. Yes, next.
Much obliged, Lordship.
Item number 10.
Contempt.
Please, Your Lordship.
Yes, complied.
Yes, Your Lordship.
Complied.
Yes, Your Lordship.
Yes, complied.
He has also already joined, Your Lordship. Joining report is on the next.
Learned Counsel.
May,
Miss. Yes, yes.
Your Lordship, for contempt number 1, let the additional EGV Sokrin name be reflected, and for number 2.
You give your presence.
Okay.
So and so appears for the respondents number so and so. Okay. Miss Lovika, Learned Counsel appearing for the respondent number
2.
2 has produced an order dated 6th of August 2025 issued by the Principal Chief Conservator of Forest and Head of Forest Force appointing the petitioner as a forest guard under the Department of Environment, Forest and Climate Change Department. Full stop. She has also produced a joining report of the petitioner, who joined on 8/8/2025. Your name, please?
ILMG.
Ms. Simchen, Learned Counsel appears for the petitioner, endorses the statement that the petitioner has been offered appointment and has joined. The orders of this court passed in the order dated 27/2025 in WPC number 37 of 2023 having been substantially complied with, this contempt petition is closed on compliance. Yes.
For hearing, item number 13.
13. Yes. This is of 2019.
My lord. Yes, my lord.
Yes.
May I please, Lordship?
Who's for the state?
My
Who will
brother-
appear?
My brother Moyes.
Okay. Yes, can we complete it today? We can complete it today.
Yes.
Okay.
My lord, before I open the file, just a short item. The petitioner and his family, they are the private land owners at Procedural under Peck District, Nagaland. In 1976, the Transport Department, Government of Nagaland, proposed to start constructions of quarter for the Transport Department at Procedural on my land.
Yes.
Then, without following any land acquisition procedure established by law, especially in Nagaland 1965, Land Acquisition Act 1965, taking full advantage of the ignorance of the public, that time 76, hardly Lordship will find few Naga graduate in 76, 70. And that was interior area. Government had just taken my land without following any due process of Land Acquisition Act 1965 of Nagaland. So now that is my whole case. Now the law provides that to acquire land from private parties, Land Acquisition Act has to be followed. So in the present case, without following the land acquisition procedure, they have taken my land and no compensation was paid. This is my case, in short, my lord. Now I'll just open my petition. Now the rest are all technical issue only. And here, para 1, I have made specific allegation that government had taken my land without following due process of Land Acquisition Act. In their affidavit, they have just admitted. Once the paragraph 1 is admitted, then the whole thing is covered. I'll just read of paragraph 1, my lord.
Yes, sir.
Read petition. Paragraph 1. This they have admitted in their affidavit. So once they have admitted, then the matter is, law is settled. Para 1. That the humble petitioners are bona fide citizens of India, a permanent residents of Procedural Town, District 5, Nagaland. By filing this writ petition, the petitioners are seeking direction.
Yes.
Well, the petitioners are seeking direction of this Honorable Court to direct the state respondents to pay an adequate land compensation as per the land acquisition laws, as the petitioners have been deprived of their life and livelihood of the illegal possession of the land by the state respondent without following any due procedure of laws under the law of the right to fair compensation and transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013, the Land Acquisition Act 1894 and Nagaland within bracket Requisition and Acquisition Act 1965 for establishments of Nagaland State Transport at Procedural by constructing permanent building of Nagaland State Government Office, Staff Quarters, Garage and parking since 1976 till date, despite of various representations and requests to the state respondents. Being aggrieved by such inaction and illegal action of the state respondents, the petitioners are filing this instant writ petition under Article 2 to 6 of the Constitution of India. The British issues. So this fact has been admitted in the affidavit in opposition by the state. No comments. So that means they have accepted that my land was taken without following due process of law required under Land Acquisition Act 1965. That was prevailing that time. Under Land Acquisition Act, Section 7 notice is required to me. No notice. Section 8 is compensation to be paid to me as per Nagaland Land Acquisition Act, my lord. Not done. Then paragraph 2, my lord. The short facts of the case in hand is that sometime in the year 1976 and 1977, the Nagaland State Transport Department, Nagaland, instructed the town committee public leaders to search a suitable plot of land for establishments of Nagaland State Transport Office, staff quarters, garage, and parking area to be acquired by the department. Accordingly, Sri Yehuse Turen, late Zoni Letu, and late Funinu had approached the petitioner's father, late Mikalomi, and other landowner, namely Nipelo Kapo, for donation of 232 into 149 square feet area of land for the said purpose. Therefore, the petitioner's late father had donated the land measuring an area of 132 into 82 square feet situated at Ketupa, Colony de Procedural Town Pack District, out of total land measuring 232 into 149 square feet. Subpara 2, B2A, that there was an oral agreement between the Department of Transport and the petitioner's late father on the terms and conditions that if the petitioner's father donated the land to the department, an appointment of one grade 4 post / land compensation or any contract work for the land acquired by the respondent would be given to him. 2B, that it is an admitted fact that the land occupied by Nagaland State Transport situated at Ketupok Colony, Fitzroy Town, Phag District belongs to two private individual landowners, namely one, Nipelo Kafo, and two, petitioner's father, namely late Me Kalomi. Out of the total land measuring an area of 232 into 149 square feet, an area of 132 into 82 square feet belongs to the petitioner's father, late Me Kalomi, and had been in physical possession of the said land since time immemorial. 3. Paragraph 3. That the homestead land measuring an area of 132 into 82 square feet situated at Ketupok Colony, Fitzroy Town, District Phag, with specific boundaries, is a self-acquired property of the petitioner's late father during his lifetime. And upon the death of their father, late Me Kalomi, the said homestead land was inherited by the petitioners, being the sons of late Me Kalomi, as per the Chakasan customs and practices. In this regard, the chairman and GB of Ketupok Colony, Fitzroy Town District Phag, Nagaland, has issued a land ownership certificate certifying that the above mentioned land belongs to petitioners. NHA 1 is my document, my lord. NHA is my document. Page 15, madam. 1-5.
Can you tell me one thing? I'm just trying to understand. Your page 9, para 11.
Yes, madam. Page 9, para 11. Yes, madam. That it is respectfully submitted that in a similarly situated case, facts, this court in Srimal so and so held that, quote, the only recourse open to the court is to issue direction to the government to hold inquiry and to ascertain as to whether petitioner was the original owner of the land in question. This shall be done by affording adequate opportunity of hearing, including personal hearing to the petitioner. On inquiry, it is found that petitioner or his predecessor was the original owner of the land. The stress opponent 1 to 5 shall take necessary steps for making payment of just compensation to the petitioner in accordance with law. This shall be done within period of 3 months from today.
Are you satisfied with this?
My lord.
If
Done.
this is done, you are satisfied?
My lord. Otherwise, short. Now, God, from time to time, when we damages this, that I always insist that let them produce land acquisition.
We will not go into a roving inquiry to find out whether you have a case or not. Writ jurisdiction, in my understanding, is you make a prima facie case, you give me the correct documents. If the law is in your support, you have a case, I will listen to it.
I agree that.
Unless the government can show me something else. Now, from here what I find is, you are now aged 39 years.
Correct.
So in 1976, where were you?
76, my father was there.
But your existence was null and void. Now, your father has also left this world.
My father died.
Yes. So
this-
now, the only thing that you are now claiming is in your prayer portion is that either give me the compensation for the land,
Yes.
or you consider my case for appointment
In
somewhere.
lieu of compensation, that's I'll be happy
me a job.
because my bread and butter.
What is the age limit?
Nagaland.
Upper age limit
For the Nagas in tribal area, maybe up to 35.
It's 39. Oh yes, the
Correct.
affidavit says.
No case.
No job.
No
job.
no consideration.
No job because
Very fair enough.
very delayed.
Fair enough.
If you had filed this writ petition in 2012, maybe a consideration.
Fair enough.
It came after.
So therefore,
Only, yes, he is asking for an enquiry to be made whether the land belonged to him, whether there was actually any payments done.
Yes.
And if no payment has been done, take steps to compensate them.
Lordship,
And it is not on today's rate or that day's rate, whatever the law is.
my learned friend is very clever, so
I'm
is
not
coming
as clever as
this
my
way.
friend.
We will keep it, he's referring to your client
Yes,
and not to you.
My
yes,
lord.
no, everything was done in 1977. Issue is 1977 issue. And after 48 years, suddenly my friend is coming and saying that I have to be compensated. My land was not acquired as per the provision of the Nagaland Land Acquisition and Requisition Act. All of a sudden is coming after 48 years.
No.
So that is a very funny thing. And without going into the merit of the case, Your Lordship, this has to be dismissed on the ground of delay and laches at the threshold.
Okay.
That is my first prayer. Coming to the things, Lordship, you kindly appreciate my additional affidavit.
Additional affidavit by the
I have
state.
filed one additional affidavit. It will be in the file. Additional affidavit by the state.
Admit card, this is
7/4/2025.
affidavit reply.
Additional affidavit
against
was filed
additional
on
affidavit.
7/4/25. State additional affidavit.
You have filed it 1/4/25. 7/4, yes.
7/4/2025.
Yes. 7/4, yes. What do you want
State
to
additional affidavit.
Yes.
Once you see that, Lordship will you got it, Your Lordship?
Yes. What do you want to show here?
State additional affidavit.
They have also
Well,
filed a
we have
reply.
projected the steps undertaken by the state in the additional affidavit. Lordship, may I read from page 2, paragraph 2?
Yes.
That the state respondents had filed counter-affidavit in the instant writ petition. However, when the matter was heard on 11/3/2025, this honorable court, by its order, on the same date, has directed the state respondents to file an additional affidavit in regard to appointment of John Kafu, son of Nibilu Kafu, to the post of mechanic helper, and also order issued to Wigby Lomi. Wigby Lomi is the father of the present petitioner. Wigby Lomi is the father of the present petitioners. There are two petitioners.
Then why is the writ petition contains his name?
My lord, just to clarify, there are two private landowners. He is referring to other landowners. I'm not talking a concern about that.
What
There are two landowners.
Just a minute. There are two landowners,
Yes.
Wekpi Lome and Medongulo Lome.
Both of us were brothers.
Yes.
But Kapo, John Kapo is another private landowner. He is not before this court because he got appointment.
No, I'm not saying that. What I'm trying to understand is
Yes.
Yes.
in
Lordship,
the additional affidavit,
Ah.
they have given a document at page 9 of that document,
Yes.
page 9 of that affidavit, which is annexure 2.
Correct.
It is to some Mr. Vekupi Lomi
Yes.
of the year 1991.
Yes.
Which year? This 1991,
Yes.
where there was a work order in
Yes.
favor of
Petitioner.
Vekupi Lome.
Yes.
Now you have filed an affidavit in reply saying that you were 15 years of age in
In 1991.
Okay.
I have filed, I'm going to explain about that. If my learned friend finish, I'll just
No,
explain.
but there's another interesting thing. At page 3 of that affidavit, you are saying petitioner number 1, late Wekpi Lome.
Yes.
So he's expired.
He died. My brother, both of us, unfortunately, during the pendency of this petition, he died.
No, Wekpi Lome is no more there. Then.
Both of us brothers. So when the writ petition is pending, he died. He died.
So,
Only the brother petition number 2 is sorry.
who
Petition
is there?
number 2
The other person, what is his name?
Medolungo
Medolungo Lome is there. So now we proceed for Medolungo Lome,
Correct,
not
correct.
for Wekpe.
No. The correct exact things, man.
But have you brought it on record that this person is
Yes,
expired?
I have already filed. Death certificate was filed as per the court's direction.
So he has not been struck off.
Should be struck off.
Should be struck off
Should
first.
be struck off. Because his name cannot be, I have brought to the notice of the court long before.
Now, if the state stand that if Wekpe Lome was compensated with the tender work, so let us say if he has
My
given a
lord,
contract work, will it also suffice against petitioner number 2?
Yes.
I have explained in my affidavit that
Will
it's not
it suffice? The land was your grandfather's.
my father.
My father. And then Wekpe Lome and Medolungo Lome, they
They are
both
all
filed a
from
case
the
that
same-
it was my father's land.
Yes.
Please give us
Yes.
either compensation or job.
Yes.
Now, they say that one of your brother was given the job. You are disputing it, no doubt, but
Not brothers.
you were given the job.
No, my lord.
Give me the family tree. Who's the father?
Yes.
Let me understand. Who is the father?
My father is Mikalomi, late Mikalomi.
Mika Lomi. Okay, late. He is the father.
He is the
Then,
father.
who is this? Who are the two sons?
John Kapo.
The two sons, who are you?
The two sons.
Nepelo Kafo and
No, my
Mika
lord.
Lomi.
No, my lord.
There were two persons.
My lord, please come to the writ petition. I have given the detail. Page 3, cost title.
Yes, I'm trying to find it out.
Wekopalomi, Medongololomi, the brothers of the same father. John Kapo, he is from another different village and different family.
Page 5, para 2. If I understand the facts, I can dictate the judgment. That is what I'm trying
That's
to find
what-
out. Okay. Page 5,
Yes,
para 2b.
correct, madam.
They are saying that the land belonged to Nepilo Kapfo and Mika Lomi.
Correct. Absolutely.
Mika Lomi
Is my father.
and you are two sons.
Mikalomi has two sons.
Petitioner number 1 and petitioner number 2.
Absolutely.
Now, both of them together file a case saying that we should be compensated for the land that was taken from my father.
When it was pending, the petitioner number 1 expired.
So,
That is coming.
let me understand that there were two persons who said that it was our father's land which was being taken by the government.
Yes,
we should be either given a compensation or we
Correct,
should be given the job. During pendency, state says that we have given a contract work to petitioner number 1.
Yes.
Correct.
Petitioner number 1 files an affidavit saying, I was only 15 years of age.
Underage.
You could not have given me a contract.
I'll
This is-
certify-
No, I'm just trying to understand what the statements are. We'll come to the arguments later, truth or lie. So he says that I was 15 years of age. You could not have given me a contract. Then he dies.
Yes.
So today we have one petitioner
Only one
standing before us.
Yes. Only one.
The petitioner number 2 is before us, and what we have now to find out is whether any contract was given to petitioner number 1. If it was given, if no, things are different. If it was given, if the contract was given, would giving that contract work to petitioner number 1 also be sufficient against petitioner number 2 because the land was their father's and giving work or giving either job or contract to any one of the sons will be enough?
Yes.
That is your case.
Correct.
That is how I understand it, and that is what we will try to decide.
Absolutely.
Anything more, nothing.
Your Lordship, for your
Now let us-
understanding, I'll
Yes.
take you,
You were
Lordship,
taking me
read
to the-
petition. Read petition.
Yes,
The prayer of the petitioner.
yes.
The prayer of the petitioner.
Oh,
Page,
this Medulungu.
Lordship, you will find in page 12, the prayer,
Yes, page 12.
yes, of the writ petition.
Appropriate compensation is what he's asking for.
Page 12. You got it, Your Lordship? Yes. Prayer. Number A. Direct this respondent to acquire the land as per the Nagaland Land Requisition and Acquisition Act 1965. And right to fair compensation and transparency and land acquisition, rehabilitation and resettlement act 2013. This is an act.
Yes.
This is an act.
Of 2013.
Number 2 is an act, Your Lordship, passed by the Parliament. Passed by the Parliament. And this has not been, since it deals with the land, ownership of land and its resources, which is protected under, Your Lordship is well aware, under 371A. So, something which touches 371A must be approved by the State Assembly. So far, as of today, the state has not approved
What?
that very fair, right to fair compensation and transparency and land acquisition and rehabilitation and resettlement act 2013. It is an act passed by the Parliament.
It has not been, it is not followed in the state of Nagaland.
It has not been, Your Lordship, it has not
No,
been.
a central act, unless it excludes the state, how can you say that it is not?
Applicable to all.
It is
I
to
have
be,
the act.
it is to be applicable to the state of
Well,
Nagaland.
in any case,
So that will be a dangerous proposition. I will not go
Your
into
Lordship, in any case,
that. It is a dangerous
these
proposition.
two are not applicable. Now come to the number B. Direct the state respondent to pay an adequate land compensation as per prevailing market rate with interest from the date of possession till date. Number C. Direct the state respondents to consider the existing landowner scheme notification dated 3rd March 2018 implemented in the state of Nagaland. This is very important. This is applicable, and this notification is holding the field right now. So I'll take Your Lordship to the notification. What? Lordship, you will find the notification and page 34 of the writ petition. I have also annexed, but for your convenience, I'll take you to the page 34.
How many notifications are there for this landowner, this thing?
This
Every case
is the latest. This is
I'm
the
getting a
latest
different notification in different petitions.
My
How
lord,
many notifications
now,
are there?
Now only the latest is only there are earlier in
Something in 2006,
Yes.
then 2017 there was one.
1996. 1996, there was a simple notification from the education department.
Education.
Yes, that
We will
if
build a school and we'll give you the job.
that if anyone's land has taken, then we'll give you grade 4. So from there, to say like that. Now finally, the state government has come up with a policy. Okay, fine. Henceforth, if we are going to acquire any land, we have followed Land Acquisition Act. Past history, if someone's land had been taken,
This is 2018 Act.
Yes,
Office memorandum.
that is the latest things.
Yes,
So
this 3A, 3B, I have seen, yes, sir.
this is nothing to do with this.
May I read the
Please.
notification, Your Lordship,
That notification, yes.
for your understanding?
Clause 3A or 3B. 3A and 3B is what? This I've gone through.
May I read, Your Lordship? Dated notification
No, we come down to 3A and 3B directly.
3A.
In cases prior to 26.
In other cases prior to 26/7/2005 and subsequent to ceding of administrative and block headquarters on freely donated land, where a specific written agreement exists providing for employment to the landowner, the claim of the landowner for employment should be settled in terms of such agreement. So that is two landowners, one landowner, was given this mechanic, the work of a mechanic, helper. So that is called. He has satisfied that very criteria and he is satisfied. Now regarding the present petitioner only, that is, I'll read number 3B, Your Lordship. If any client for providing employment as a result of oral agreement, the department concerned shall refer the matter to the Deputy Commissioner of the district concerned, who shall examine such client carefully, including whether any employment or any other facility, including contract or supply order, has been given in the past. Written statement from the witnesses, that is government officials of the concerned department and the district administration and village functionaries present at the time of such oral agreement, should be taken by the Deputy Commissioner. The recommendation of the Deputy Commissioner should be referred with relevant documents to the Department of Land Revenue for advice in such cases by the department concerned. 3C, Your Lordship. It is also clarified that it is not the policy of this government to provide employment to the landowner in perpetuity. The employment of the landowner, if permitted by verifiable and valid agreement, is limited to the person first appointed as the landowner and government servant, and does not entitle his descendant for further employment on his retirement from service. After the appointed landowner retired.
That is
or
not
vacates-
important. That is not important.
that is not the point. But Your Lordship, 3B, you'll find whether any employment or any other facility, including contract or supply order, was given. Lordship, I'll come to that. Lordship, you'll find. That means either employment or contract or supply.
Either of the two, yes.
That will suffice if the lane is given. Now, I'll take Your Lordship to my additional affidavit, page 3, para 4. Page 3, para 4. That it is respectfully submitted by the answering deponent that the Office of the General Manager, Nagaland State Transport, Dimapur, Nagaland, has issued order for the construction of maintenance center at Wapzuro to the present petitioner, Sri Wakefield Lomi of Wapzuro Town, under Hek District, by its office number such and such, dated 21/3/1991.
Yes.
So now, Your Lordship, contract was been given. Lordship, you will find Lordship, I have the original order of Lordship received from the file. Lordship, be kindly below the flag 1.
Okay, huh?
Flag 1, that is the construction work we have given. 1991. 23
Invitation of tender.
And then Lordship, will please appreciate flag 2. No. Where's the flag 1? So everything is there, Your Lordship. And then the petitioner has put his signature. Lordship may see flag 2 also. Very old document, 1991 document.
This will be very tedious, you see. The signatures are different from the Wakalatnama. The signatures here, nothing matches.
He was minor. That time.
But we cannot say that it is manufactured. Whatever it is.
Either of the two is manufactured, this Wakalatnama or this.
Bakalatnama was executed by the living person.
I understand.
But that was signed by the Bokas, or the ghost.
No, that we will not go into because we are not required to go into.
That's why we keep.
No, during those days, it was like that. Not, it was like we do this stage, 1991, long time back. I was in class 12, 1991.
1991. So how do we know to whom it was given, this construction work? I don't know.
My lord, if
How do
I'm
we
allowed
say
to
that
read.
he is the person?
So now, what is the question? My question is, Your Lordship, before Your Lordship, what is the question of, again, acquiring the land as per the Nagaland Land Acquisition and Requisition Act, and
We are not going into those issues for the simple reason, once you have taken a stand that you awarded him a contract, he has taken a stand that I was a minor, this contract is not given to me, it is to someone else, I don't know. That becomes a disputed question of fact. Can I
that
go
is
into
why
it?
I'm saying. That is
Can I go into it?
Well, I may be allowed to just read out
Yes,
my
yes.
reply.
I have seen it, sir.
Yeah.
Because just a few minutes ago I said that you were born in 1976 and therefore you were only 15 years
No.
of age.
Number
I've
one.
already said that.
Number one. Number
Your,
two.
Your Lordship,
Ah,
Your Lordship,
Yes.
we have a large number of this kind of cases,
ah,
land ownership, appointment, that and that, in this court.
ah.
Now, once something is given, contract work is given, then that suffice. One employment is given, that suffice. Now, my friend, learned friend, is coming, even though we have given the contract work way back in 1991. He is coming again that it has to be compensated properly as per the prevailing rate.
That
So,
is what
what is the infringement of his enforceable legal right in this case? We have done what we have to do as per the standing notification of the state. We have done. So, my only question is, where is the violation of his enforceable right by the state? So, this, without taking so much time, this must be dismissed.
Yes. Understood.
My
So
lord,
anything more, sir?
No, if your lordship asks me something, I'll reply.
So
But
there are two grounds you are taking. Number one,
we have
that there
given
is a delay
this thing,
in approaching
48 years.
and the second ground is that you have already given a contractual work to the petitioner.
Supply work
number
we have
one-
given.
To petitioner number one, and if that is given, it suffices for both petitioner number 1 and 2 because the land was their father's and you were obliged to give only work to one of them. Those are your two
So
arguments.
whether my friend is saying that he was 15, whether he was 15 or 55, we don't know, but his name is there. How? So now, 15, a person of 15 years can sign.
is it permissible under the law? If that is submission of the
Minor contract agreement,
No,
government,
no,
That
no,
may be
no, no,
recorded
no,
by law.
no,
deposit
no.
money, the earnest money.
That
No,
may be
what I'm
recorded-
saying
that
is-
may be recorded, my lord.
What I'm saying is, I have not manufactured this document, your lordship.
No.
I have not manufactured
There
this
is, there
document.
is no such allegation, sir, that it is a manufactured document. We are not considering that aspect of the matter
So
at all.
his age, though he knows. I don't know his age. He might say, I'm 99. That is
What does this person says, respondent number 1 in his affidavit, what does it
My
say?
lord, may just to satisfy
Yes,
lordship.
yes, please, please.
Affidavit in reply to this additional fee filed by government, just my learned friend has read out paragraph 3, just paragraph 3, so that the mind, after that I'll show one judgment, two judgment, that much. Affidavit in reply filed by petitioner, against the affidavit, additional affidavit filed by state.
Para 3 you are
Para
reading.
3, para 3, just
Oh,
para
this is a long paragraph, okay.
May I read it? Yes. Just to clarify what my learned friend has said. With regard to the statement made in paragraph 4 of the additional affidavit filed by the state respondent 1-3, the deponent denied that the office of the General Manager, Nagaland State Transport Dimapur, Nagaland, has issued work order for the constructions of maintenance of center at Procedural to petition number 1, Wekupalomi, White, work order number so-and-so 21-391. The deponent also begs to state that the date of birth recorded in the admit card of high school leaving certificate examination was on 25/5/1975. Based on such record and after confirming from the biological parents, Wekupelumi's date of birth was confirmed as on 25/5/1975. Going by his actual date of birth as mentioned above, Wekupelumi was only 15 years old in the year 1991. That being the case, it is not expected that any government contract work could be awarded to him by any competent authority under any circumstances. Both petitioner 1
We
and
have
2.
gone through it, sir.
Now, Lordship, my learned friend is raising one question.
No, this time.
Learned friend is raising the delay. Land was occupied, taken over in 1976, 76, 77, because there is no record for them. They have not prepared any acquisition follow procedure. Now, therefore, I have come before the Supreme Court in 43 years. 43 years by filing this petition. Before that, I started submitting representation after representation. Now, I'll show Lordship one judgment, which is similar to this case, factually also similar. Principles are the same. I'll read the entire paragraph so that Lordship will easily understand.
Okay. What will I do with this? Give me the book.
Book has given us.
You've given the book.
Who's it? 2020 Volume 2 SEC.
Vidya Devi.
2020 Volume 2.
Land acquisition.
Land acquisition.
Delay. Land acquisition, delay, condone, yes.
Yes. My lord, I'll just start. It's similar facts. So that's why I wish to read short facts only. Para 2, my lord. May I read it? Para 2. Similar, that's why I want to read similar. I'll skip the irrelevant parts. Para 2. Because my learned friends questioning are raising the delay. 2. The respondent state took over the land of the appellant in 1967 to same case with me, 76-77, for the constructions of the major district road being the Nadan Sujandurpur road, a major district road without taking recourse, my lord, the important part, without taking recourse to acquisition proceedings or following due process of law. The construction of the road was completed by 1975. I'll skip para 3. Para 4. In 2004, some similar situated persons whose land had also been taken over by the state respondent state for the same public purpose filed WPC number so-and-so, title Anak Singh versus State of Himachal Pradesh, claiming company before the High Court of Himachal Pradesh. The High Court by order dated 23/4/2007 allowed so-and-so 2004 and directed the state respondent to acquire the land of the writ petitioner under the Land Acquisition Act 1894. 5. Pursuant to the order of the High Court in 2008, the state respondent initiated acquisition proceeding under the Land Acquisition Act 1894 only with respect to the lands of the writ petitioners and not the other landowner whose land had also been taken over. Then paragraph 6, 7, these are relevant, my lord. The appellant submit that she learned of this proceeding in 2010 when she, along with her 2 daughters, filed WPC number so and so in 2010 before the Himachal Pradesh High Court, praying that the state be directed to pay compensation for the land acquired in 1967 to 68, or in the alternative, direct the state to initiate acquisition proceeding under the Land Acquisition Act 1894. Paragraph 7. The respondent state filed its reply before the High Court, wherein it was admitted that the department had used the land in the ownership of the appellant for the constructions of the Nadon Sujanpur Road, a major district in 1967-1968. The state had been in continuous possession of the property since 1967-68, that is, for the last 42 years, and the title of the state respondent got converted into adverse possession. It was admitted that the statutory remedy available to the appellant was by filing a civil suit. 8. That state has further admitted that, and I'll skip 8 then. 9. That the High Court
Yes, I have gone
Yes.
through. I have gone through.
So now, delay, there is no delay at all in Supreme Court. In this case, Supreme Court says, the moment you have been dispossessed, cause of action continued from that day, in this 1967. In my case, 1976-77, till now, cause of action continues. Similar case. Here, the state government raised in Himachal Pradesh, why you came after 42 years? Supreme Court said, no. High Court finding was wrong on delay because
There it was 42 years.
yes, I need my 43 years.
In 1990,
Six-
in 2020, it was 43 years. Add 5 years.
Yes.
And in your 43, add 5 years, 48. Exactly same.
Exactly same. So therefore, Supreme Court says, basic thing Supreme Court has said, whichever state may be, follow the procedure.
We will
Like-
consider this.
My-
Yes, we will consider this.
Yes.
Anything more?
That much, that much.
Any other? What are the other judgment you are giving?
Your Lordship,
Just a minute. Sir. What is the other judgment you are
Yes,
giving?
I'll show. Another judgment is
On what?
the other day, my friend was saying, if this is allowed, floodgate will be open. Supreme Court
floodgate,
judgment
okay.
says.
Okay, next.
I'll show.
And what is the other
Here,
one?
here,
Number
my
3.
lord, that is similar. I don't need to use this.
Okay.
These two. Now, floodgate, page, paragraph. Paragraph 23. The other day, my learned friend was submitting. This is year 2007. Year 2007, Supreme Court. Page 1706. But the relevant page is 17 paragraph. Paragraph 23, my lord. Relevant page 1710, relevant paragraph 23. Just short. So how can my learned friend that
Yes.
without following due process, how can they say no? If this court allow, it will open floodgate.
Yes.
Supreme Court discourage all this.
Yes, sir.
my Lord,
Have you seen Vidya Devi? The judgment Vidya Devi?
Yes.
That's 2022 SCC 569. delay.
Yes. No delay.
well, Nagaland, we have a very, in Nagaland, in our state, we have a very peculiar system of land holding system. So, not similar with other states, even Northeast. Because here in Nagaland, we don't, government, state, don't own any land. Like Assam still owns, as per the Assam Land and Revenue Regulation. Nagaland, though, state, we don't, land is owned. Owner of the land is either an individual, a clan, or a village. State has to buy from the landowner, or in cases where government offices are to be established, landowner used to donate. And lieu of that donation, we used to give fourth-grade appointment or some contract. If some contract comes out, we used to give that. That is the thing. Because we don't own any land. So normally in village rural areas, this Procedural town is a small town on the way to Peg, which is a district, which is district headquarters. So it's a very small town. So during that time, 1997, when the state has initiated for development of the NST, establishment of the Nagaland State Transport Office, it was settled somehow with the landowners. And look at, and we have constructed that. Because it was a public utility, you know, your lordship is well aware, public utility service. So that we have done, and we have given the appointment also to one landowner and a work order to the present petitioner. So it was subsided. It was done, fairly done. And while situating like that, like this, now all of a sudden my learned friend has come and said, no, I have to be compensated as per the prevailing rate. I have to be these things. Lordship may kindly see page 2 of my affidavit in opposition, original affidavit in opposition.
When did you file it?
25/3/2001.
2021.
2021.
25/3/2021. Yes.
We have similar, lot of cases of this kind. So, Your Lordship, we should be very cautious, very careful. Because, may I read para 4? That with regard to the statement made in paragraph so and so of the petition, the answering deponent respectfully states as follows. Number A, that the total area which was donated collectively by Sri Nipilo Kafu, that means one who has been given the employment, and late Mika Lumi, this is the father of the petitioner, is only 26,136 square feet, which was surveyed by order such and such, dated 17/12/1990, and out of which 1,390 square feet was acquired on payment of rupees 13,000. That means certain amount was also given to the petitioner.
Then what do you say about this,
Don't time back.
para 6 of that affidavit?
Further,
That the land in question-
I'll continue, Your Lordship. And furthermore, the deponent begs to say that the contract work was awarded to the petitioner, Mr. Whitby Lomi, for the construction and of maintenance center at NST of 0 White so and so. That is, Your Lordship has just seen the work order. So that is what we have done. We have done our part. We have done what we are supposed
Okay, we
to
will
do.
consider that. We will consider that aspect also.
My only praise is follow the process of land acquisition and then pay us. That much, I am not asking anything more, anything less, my lord. Because I have not followed the procedure laid down by law. Lordship is very much aware with your experience. Any judgment by the Supreme Court under Article 140 says, to say that any judgment by Supreme Court is the law of the land. He's saying that Nagaland is different. What is that kind of submission cannot?
No, I'm not saying that the judgment of the Supreme Court
Article
Apex Court is wrong.
140,
What I'm saying is the peculiarity of the Nagaland in regard to
Article-
ownership
Was
of land.
this matter heard by some other bench in any point of time?
Earlier, but they failed to produce the record, therefore this is listed today.
No, it was heard by, earlier it was heard by?
If I'm not wrong, Justice Bauti, and directed the Learned Council to produce the government record, so it was produced today. Well, Lordship has found the signatures are different from Vaglanama.
No, I will not go by that. I am
I
am no authority. I am not that.
So my only submission is that follow the procedure, land acquisition procedure, follow it, because that is the law of the land. 1965 is Nagaland land. Only after that it was acquired without following that procedure that much only. And as I said, my learned friend is saying that no, Nagaland situation is different. Supreme Court judgment will not bind that. Article 140 of the Constitution is very clear. Whatever judgment laid down by Supreme Court, that is the law of the land. Yes, ma'am.
ठीक है. Got a meeting today again. 1 o'clock. 2, 3. Okay, इसको dispose दिखा दीजिए. Dispose it off.
Madam President.
Any more? List over? The list is only over because of so many adjournments. Why so many adjournments? Bail. All this, why adjournment?
Lordship, we are so privileged to appear before different judges coming from different background, honestly.
Yes.
We feel that privilege.
Because
if we have appeared before the same judge, sometimes we also don't learn many things. But coming from different background, we learn many things. We are privileged to appear before every judge as well.
when I used to appear in Meghalaya, then the Gauhati High Court judges used to go there. And Meghalaya had that privilege because every week it would be a different judge in the same bench.
That's what we feel.
And it was a variety. And we also used to visit as lawyers.
We learn many things. Through mistake, we learn.
Not only mistake, other things also together. Let's just staple this up. I saw some notes. Thank you.
print করি print out না copy দিব print out ভাল লাগে না তাত পঢ়া ভাল না নাহি যাও 1 3 না 1 3 I say it.